November 4th, 2008 was a bittersweet moment in the American history of equal rights. On the one hand, for the first time in American history, an African-American president was elected. On the other hand, it was the first time in American history that an existing civil right that was being used and enjoyed, frankly, was taken away. The right to be married, which same-sex couples in California had, and it vanished with Proposition 8. And today, 4 months after Proposition 8 passed, the equal rights movement is galvanized. Hundreds of people marching on the streets of San Francisco last night, gathering for candlelight vigils on the steps of state buildings, protesting outside the California Supreme Court building this morning, then huddling around Jumbotron screens to witness what was happening inside. The California Supreme Court today heard arguments on Prop 8 for the first time since it passed, and the legal fight here is actually very narrowly cast. The debate in the country, the debate between rival groups of protesters outside the courthouse today, that debate is very roughly in favor of gay marriage versus against gay marriage. But if you want to be smart about this and actually grasp what the legal fight is about, the fight that will actually determine whether or not same-sex couples have the right to marry in California, it's sort of important to get the details right here. Today's hearing was about 3 really specific particular points. First, is Prop 8 invalid? Should it never have been on the ballot in the first place? Because it's a revision of the state constitution instead of an amendment to the Constitution. Revision versus amendment? What's that mean? Stay with me. That will be explained uno momento. Second point, does Prop 8 violate the separation of powers doctrine? Is it blocking the courts, a co-equal branch of government, from enforcing the Equal Protection Clause of the state constitution? And third, if Prop 8 is constitutional, if the ban stands, what is the effect on those 18,000 same-sex couples who married in California before the ban came down like a hammer? The arguments were today. The court now has 90 days to decide. Do you want to know what's likely to happen? Well, we're joined now by San Francisco City Attorney Dennis Herrera. He, along with others, filed the lawsuit that the Supreme Court heard today, arguing that Prop 8 is invalid because it's a revision rather than an amendment to the Constitution. Mr. Herrera, thank you so much for being here.
Thanks for having me, Rachel.
Can you explain to us non-lawyers why the whole revision versus amendment argument is important here?
It's important because it's about equality. Not just marriage equality for gay and lesbian couples, but for equality for all Californians. And the people of California, in their wisdom, put limitations on their ability to change the Constitution such that when there's a structural change to state government or when a fundamental right is implicated, a higher level of scrutiny is required before something is voted on by the people in a constitutional amendment, such that you have to have either a constitutional convention or a 2/3 vote of the legislature before the matter is put to a vote. And that was done precisely because they recognized that some things were so important that we should be more deliberative as we consider them and not just consider them in the heat of a political moment.
Overall, how do you think that argument was received today? News reports do seem to indicate that the justices were leaning in favor of leaving the gay marriage ban in place. How did you feel that it went?
Well, I thought that my Chief Deputy Terry Stewart did a wonderful job in specifying what really was at issue. And I think what was very telling was the Chief Justice's questions of Judge Kenneth Starr, who, representing the other side, said very, very clearly that if Prop 8 was allowed to stand, issues such as free speech and other fundamental rights that many of us take for granted would be freely able to be changed by a vote of the people. And certainly that's not what we understand when we recognize that we have 3 co-equal branches of government with an independent, non-political judiciary there to act as a check on the in order to protect minority rights. So they asked a lot of tough questions of both sides. They recognized that this is a novel area of the law. There's only been 9 cases in this area of jurisprudence. Quite honestly, we did raise some novel arguments that talk not just about saying that a revision is required when you have a structural change to state government, but also when you have the right that is protected by those structures is also at issue. So I think that they asked a lot of difficult questions, but I think that what was clear, starkly laid out, is what the stakes are. And that has implications not just for gay and lesbian couples, but for women and other disfavored minority groups here in California, as well as the broader population when it comes to the protection of their constitutional rights.
Just to be clear, Ken Starr did actually argue today, people do have the raw power to define rights. I mean, I know you're saying that the Chief Justice questioned him sharply about that. That's an astonishing statement about about his view of American jurisprudence.
Absolutely. From my perspective, he wasn't bashful about it. He was very, very clear in saying that the people have an unfettered right to take away rights that all of us hold sacred and take for granted. Specifically, he referred to freedom of speech. Now, why I think what we all need to be concerned about is the fact that we have an independent judiciary there precisely to protect those rights. We also have a limitation that the people have put in the California Constitution by virtue of the fact that they have the revision process in there anyway. I think that they recognized when the California Constitution was formed that there were certain things that required such a high level of scrutiny because they were so fundamentally important. And I can think of nothing more fundamental than the fundamental right to marry and enjoy your life with the person of your own choosing.
Mr. Herrera, if the court does rule against your lawsuit and the other arguments presented today, what will be the next attempt to restore same-sex marriage rights in California?
Well, the claim that we all brought today, San Francisco as well as 15 other counties and cities in California representing over 17 million Californians, along with the National Center for Lesbian Rights and others, only raised state law claims under the state constitution. So in the event that we are unsuccessful, this is the final stop on the state law claims that we brought. It's no secret that there have been rumblings that there are political movements out there that would look possibly to put this item on the ballot within a couple of years. And that's a political battle that will probably occur in the event that we are unsuccessful. But number one, I'm hopeful and cautiously optimistic that we will be successful. And in any event, I think there's been tremendous progress that's been made in the fight for civil rights. When you look at Prop 22 that passed here in the year 2000, where it was 60-40 against same-sex marriage, and here in a closely fought election, it's 52-48. And I think a lot of that is due to the great work that's been done by the city and county of San Francisco, as well as my brethren in this fight, other cities and counties and other advocacy organizations.
Dennis Herrera, San Francisco City Attorney, thank you so much for joining us, and good luck to you.
Thank you, Rachel.
Coming up.